Division of assets in California has to be equal. It's defined in Family Code section 2550, Family Code, California. The court says it has to be either community property or quasi-community property. Quasi-community property means the community is located out of state. Now, it can also be divided not equal, either by agreement, written agreement by the parties, and if it's done orally, it has to be done in court, because as you know, when we're in court, we're testifying under penalty of perjury and we're sworn in, so it becomes binding. Now, when we divide family homes, real estate, the value we're using is either agreed upon by the parties or the closest date to trial, or if the sale is deferred at the time when the sale is happening. Now, when is deferred sale appropriate? First, the spouse who lives in the residence has to have either sole or joint physical custody of the child or children. Second, that spouse has to be entitled to child support. And then when court finally determines whether a deferred sale is appropriate, the court would look at financial feasibility, meaning the resident spouse is able to afford the mortgage, property tax. And there is a case of appeal, Horowitz, Horowitz, like zebra, that says the resident spouse is responsible for everything in the home: property tax, mortgage, maintenance fees, basically for everything. And the court considers the ability of the resident spouse to live and afford, ability to receive child support, spousal support. All of that needs to be taken into account. And finally, whether deferred sale is in the best interest of the children. The court looks how long have the children been residing, the proximity of the home to the school, the detriment if the home is going to be sold for the children, their physical disabilities and how home is benefiting them. So then let's say the court determined that living in this home with the children for the resident spouse is appropriate, and the court will order then the home needs to be sold, and it has to be, the court must put a date when the home should be sold. And it doesn't matter if the out spouse has significant separate property interest in the home. Doesn't matter. The court looks what's in the best interest of the children. Now we come to taxes. When the home is sold, then both spouses technically, if they lived 2 years before sale in the home, then they're entitled to $250,000 each, exempt from gain tax. So the court, in order to preserve that benefit, has to put in the order, or if you're a lawyer, you have to put it in the stipulation that the out spouse is so basically you have to preserve the benefit of not paying gain, and say that the spouse who is not living it is excluded by the court order. So that way the spouse who is excluded actually is not excluded, because they remain they get the benefit. And the code section for that is IRS 121E3B. Okay, just double check that. And finally, the title must be tenants in common, not joint tenants. So that's it for deferred sale on the home topic.